Hello everybody, welcome back to the channel. This is CS Balgopal Sridharan from HGPA Academy. People have made two videos in the past. Number one video was on suggested answers of CRVI December 2024. Second video was on part 2 of the question paper, and this video is going to be on part 3 of the question paper. Okay, before we begin, I will tell you two things, people. Number one is, if you have just now given your exams in December 2024, please do not watch this video right now. Watch it after 1 or 2 weeks after the exams. The reason is तुम लोग फालतू का stress लोगे. Okay. Number two is, this video is solely for the purpose of communicating my teaching skills to you and the way I have written my notes, so that in future when you buy my course, you will be very easily able to connect with the way I teach. Okay. So without wasting any time, people, let's jump to question number 1 of part 3 of CRVI December 2024. Okay, शुरू करते हैं. A key duty of resolution professional under section 25 subsection 2 subsection H of the IBC is to invite prospective resolution applicants, PRAs, who fulfill such criteria as may be laid down by him with the approval of COC, having regard to the complexity and the scale of operations of the business of the corporator and such other conditions as may be specified by the board, to submit a resolution plan or plans. The details pertaining to the process for inviting, submitting, evaluating and approving the resolution plan and the timelines in relation to them are detailed in the CRP regulations. We need to give the timelines for the following as provided in the CIRP regulations. So when a resolution professional invites resolution plans from resolution applicants, provided they fulfill the conditions, we need to find out the timelines for the following as provided in the CIRP regulations. Okay. Number one question is, publish brief particulars of the invitation for expression of interest in Form G of Schedule 1. Okay. Let's see what is the answer for this. The timeline is, people, not later than 60th day from the insolvency commencement date. Explanation for this we need to write, people. Form G contains details such as eligibility criteria and timelines for submission. It must be widely published to ensure transparency. Okay. Now, the question is, what is Form G? Okay. What is Form G? Form G is a formal announcement inviting expression of interest to prospective resolution applicants to submit the resolution plans. Okay. Number two is last date for submission of expression of interest. Okay. Expression of interest. जब resolution professional invite करता है resolution plan from the resolution applicant, what is the last date for submission of expression of interest? Okay. The answer to this question is, people, not less than 15 days from the issue date of the detailed invitation. जब तुम invitation देते हो, तुम्हें 15 दिन में resolution plan submit करना है. Okay. Resolution plan means expression of interest. Okay. The explanation for this is, prospective resolution applicants must have sufficient time to submit expression of interest. Number 3 is objection for inclusion or exclusion of a PRA in the provisional list. Timeline for that is, people, within 5 days from the date of issue of the provisional list. जब expression of interest submit करता है resolution applicant, resolution professional will see to it that the resolution applicant has fulfilled the criteria. If he has fulfilled the criteria, he will be included in the provisional list. Now, provisional list आने के बाद उसका objections, that is, who should be included, who should not be included, why he should be included, why he should not be included. ऐसे objections इनवाइट करने का टाइमलाइन क्या है? टाइमलाइन इज पीपल विद इन 5 days from the date of issue of the provisional list. Now the reason is this ensures fair opportunities for the PRAs to address eligibility concerns. I have told you why someone should or should not be included in the list. ये हमें ये इसमें आएगा objections में. Okay. Number 4th question is issue of information memorandum, evaluation matrix, and the request for resolution plans, that is RFRP. So timeline for that is within 5 days of the final list of provisional resolution applicants. Now, information memorandum में क्या क्या होता है? Just to revise you, I will tell you. It has got details regarding the operations of the corporator, financial position of the corporator, and the assets of the corporator. Evaluation matrix means financial viability, the timeline, and the compliance with regulations. And the request for resolution plans means कैसे submit होना चाहिए resolution plan. Okay. The 5th question is submission of resolution plans to the resolution professional. कितने दिनों के अंदर तुम्हें resolution plan submit करना है? Okay. A minimum of 30 days from the date of issuance of resolution request for resolution professional resolution plans. Request for resolution plan, that is RFRP. Okay. 30 days के अंदर तुम्हें submit करना है. The reason is you should have sufficient time for provisional resolution applicants to prepare detailed and comparative resolution plans. People, मैंने एक चीज में मैंने गलती कर दी. Probably expression of interest is not resolution plan. Expression of interest means I want to submit resolution plans. I will be able to follow XYZ conditions. So please take me into consideration so that you can include me in the provisional resolution applicants. After that, I will submit resolution plan. Okay. The next question is, while the insolvency professionals assist in the insolvency resolution process and be staged in the IBC, the information utility, on the other hand, collect, collate, authenticate, disseminate financial information. Explain the purpose of formation of information utilities, highlighting its obligations under section 214 of the insolvency bankruptcy code. Okay, so let's see what should be the answer for this. Information utilities were created to make the insolvency process more transparent and efficient. Okay, information utilities के वजह से resolution process should be very much transparent. सबको पता होना चाहिए क्या हो रहा है, कैसे हो रहा है, कौन से financial figures कैसे हैं. There should be no confusion in that. Number 2 is it should be highly efficient. ऐसे नहीं होना चाहिए कि एक बंदा बोल रहा है मैंने इतना लोन 10 करोड़ का लोन लिया, बस दूसरा बंदा बोल रहा है कि मैंने 10 करोड़ नहीं, मैंने 5 करोड़ का लोन लिया या फिर 15 करोड़ का लोन लिया. Figures should be accurate, which increases the efficiency. Okay. They act as digital record keepers for financial data. सारे financial data उस digital record में होता है. Now you can think of them as a trusted online vault where all the key financial details of companies are stored. इससे क्या होता है दोस्तों? इससे lenders, borrowers, and others involved in insolvency cases can quickly check the facts and cross-check the figures. Okay. Disputes about money owed or loans are reduced since the data is already verified. जब already verify हो चुका है कि X ने Y को 10 करोड़ का लोन दिया है, तो उसमें कोई कंफ्यूजन ही नहीं होता दोस्तों कि मैंने 50 करोड़ का लोन लिया या फिर 5 करोड़ का लोन लिया है. ओके. इससे क्या होता है? Efficiency will improve. Okay. I will again explain you with an example. A lender says a company owes 10 crore rupees. The information utility verifies this claim and makes it available to everyone involved. So people, insolvency resolution process will be all about immediately submitting the resolution plan, liquidate करो, जो भी करना है. टाइम इसमें नहीं वेस्ट होगा कि फिगर्स सही है या नहीं. टाइम सिर्फ उसमें जाएगा to achieve the objective of either liquidate the company or take it into insolvency process. Okay. Now, the purpose of information utility is this. Okay. One second. So this is the purpose. Okay, now what are the obligations of information utilities as per section 214? Number one is collect and store data. Information utilities must collect financial data like loans, repayments and defaults and keep it in a easy to access format. It could be like a cloud storage platform but only for financial records. एक क्लाउड स्टोरेज होगा जहां पे सारे फाइनेंशियल रिकॉर्ड्स होगा उसमें. ओके, नंबर वन इज कलेक्ट एंड स्टोर डेटा. This is how you should write people in the this is how you should write answers in the exam people. It should be very easy to understand to the examiner. At the same time, it should also communicate your point. Okay. Number two is accept electronic data. They should accept data electronically from banks, companies, or anyone required to submit it. For instance, when a bank gives a loan, it uploads the details directly to the information utility. Okay. So people, when you explain your point and after that you explain the point further with an example, it makes an impression in the minds of the examiner that isko answer clearly aata hai. You can also explain with it with examples. Examples, people, not everybody gives it in the exams. Okay, but I would always recommend you to just explain your point using examples. Okay, 99% of papers will not have examples. The 1% paper will have examples, and that is what will make a difference. Okay. Number three is verify information. Information utilities check with both the lender and the borrower to ensure the data like loan amounts and due dates is correct. Example, if a bank uploads that company X owes 5 crores rupees, the information utility will ask company X to confirm this. Okay. Fourth point is connect with other information utilities. Information utilities must work together. Sare information utilities must work together to share data seamlessly so users don't face barriers if data is stored in different information utilities. ऐसे नहीं होना चाहिए कि एक इंफॉर्मेशन यूटिलिटी बोल रहा है कि 10 करोड़ का लोन दिया है, दूसरा बोल रहा है 5 करोड़ का लोन दिया है. It should all be same. Okay. Next point is provide access. Information utilities must give authenticated data, people, authenticated data to those who need it, such as lenders, resolution professionals, or courts. If a resolution professional is handling a case, they can request the information utility to share accurate financial details. Okay. Number 6 is sharing insights. Information utilities must publish useful data trends such as default rates, which can help regulators and policymakers. If defaulters are increasing in a sector, regulators might take action. For example, if you want to make IBC a more strict and stringent law, क्या होता है? You can take help of the information utility कि भाई कितना डिफॉल्ट हो रहा है. If for example last year 500 crores का डिफॉल्ट हुआ है and if this year the default is increased to 600 crores, information utility के थ्रू हमें पता चलेगा कि कितना हुआ है डिफॉल्ट एडिशनल. इसकी वजह से IBC can be more stringent. Okay, IBC regulators can take action. Now the question is how it helps in insolvency. Number one, it saves time. No need for creditors to argue or prove debt in courts. Verified data is readily available. Number two, builds trust. Since all data is authenticated, it avoids dispute about fake or exaggerated claims. Number three, better decision making. Resolution professionals and courts get accurate financial data instantly, enabling faster resolution. Okay. तो पीपल, इंफॉर्मेशन यूटिलिटी का क्या पर्पस है आपने बोल दिया. नंबर वन इज क्या ऑब्लिगेशन है आपने बोल दिए, एंड how it helps in insolvency, ये भी आपने बोल दिया. ओके पीपल, दिस पॉइंट नो, ये जो चीज है ये बहुत इंपॉर्टेंट है पीपल. दिस इज व्हाट सेट्स यू अपार्ट फ्रॉम 99% ऑफ द आंसर शीट्स. यही तो मेन मुद्दा है ना दोस्तों. इन्फॉर्मेशन यूटिलिटी तो है ही, बट हाउ इट इज हेल्पिंग इन इंसॉल्वेंसी रेजोल्यूशन प्रोसेस, दैट इज इंपॉर्टेंट. ओके यू शुड ऑलवेज एबल टू कनेक्ट द डॉट्स. जब भी आप आंसर लिखते हो, एक चीज हो रहा है, दूसरी चीज हो रही है, तीसरी चीज हो रही है. नाउ देन यू शुड एक्सप्लेन हाउ दैट वन थिंग, सेकंड थिंग एंड थर्ड थिंग are interconnected with each other and how it is solving the purpose. That's what makes the difference, people. Okay, चलो शुरू करते हैं. नेक्स्ट क्वेश्चन. The committee of creditors recommended the liquidation of the corporate debtor of Gopi Limited. Okay, COC ने बोल दिया कि गोपी लिमिटेड का लिक्विडेशन होना चाहिए. And the National Company Law Tribunal, that is adjudicating authority, did not concur with the decision of the committee of creditors. NCLT ने बोल दिया कि नहीं, ऐसा नहीं हो सकता, you should not liquidate the company. The adjudicating authority discarded the recommendation of the COC with 87.3% of voting share and gave its own directives overriding the commercial wisdom of the COC. In the end, people, COC का पैसा अटका है ना, तो COC का डिसीजन, COC को ही डिसीजन लेना चाहिए. How can NCLT override the decision of COC? That's wrong, right? Citing relevant case laws, discuss as to what will be the merit of appeal filed by Gopi Limited against the NCLT decision in the NCLAT. Gopi Limited के पास क्या legal remedy है against the decision of NCLT? Okay? COC ने liquidation का plan approve किया, but NCLT ने liquidation का plan reject किया है. Now COC is going to appeal against NCLT to NCLAT. Now, first of all, always start with the legal provision involved, issue involved, your analysis, and then conclusion. 4 parts. Okay. I have told in the last video also, whenever such questions are asked, you should always start with number 1, legal provisions. Number 2, issue involved. Number 3, your analysis. That is important. And 4th is your conclusion. Okay. Always people write in this format. बहुत ही क्लियर कट आपका आंसर दिखता है. प्रोविजन क्या है ये एग्जामिनर विल हैव कॉन्फिडेंस कि हाँ इससे प्रोविजन आता है. नंबर 2 इज इसने आइडेंटिफाई भी करेक्टली किया है कि इशू इन्वॉल्व क्या है. दूसरी बात. तीसरी बात इज आपका एनालिसिस. प्रोविजन से हाउ आर यू एबल टू एनालाइज द क्वेश्चन. फोर्थ इज योर कंक्लूजन कि क्या एंड में कंक्लूजन है. ओके, let's see what the provision says. If you remember the provision, you can quote the section. If you don't remember the provision, please write as per the Insolvency Bankruptcy Code 2016. Okay, section 33 subsection 2 of IBC 2016. What it says is, if the committee of creditors with at least 66% voting share resolves to liquidate the corporate debtor, the adjudicating authority is required to pass a liquidation order unless the COC decision violates the law. Unless COC कोई law contravene कर रहा है, NCLT should follow or abide by what COC says. Okay. Number 2 is section 30 subsection 4 of the IBC 2016. What it says is, the COC's decision to approve or reject a resolution plan is based on its commercial wisdom. उनका commercial knowledge, उनके knowledge के तहत ही उन्होंने decide किया है, which cannot be challenged unless it violates legal provisions. Number 3, regulation 39 of IBBI CIRP regulation. What it says is, it provides a procedure for approval or rejection of resolution plan by the COC and the subsequent course of action, including liquidation, if no plan is approved. If no plan is approved, then only liquidation order is passed. इसमें लिखा है. Oh, sorry. If no plan is approved, what is the procedure for the liquidation plan? Okay. Now, provision आपने बोल दिया दोस्तों. Now let's see what is the issue involved. Whether the NCLD can override the COC's recommendation to liquidate the corporate debtor despite the decision being supported by 87.3% voting share. जब 66% ही चाहिए वोटिंग शेयर और यहाँ पे 87.3% वोटिंग शेयर मिला है, फिर भी सीओसी का प्लान रिजेक्ट कर दिया एनसीएलटी ने, whether it is right or not is the legal question involved. Now let's see what should be the analysis. Primacy of COC decision. Okay, इतना बड़ा वर्ड लिखने की जरूरत नहीं people. COC decision लिख दिया तो भी बस हो गया. The COC compromising financial creditors resolved to liquidate Gopal Limited with 87.3% voting share, exceeding the required 66% under Section 33, subsection 2. The COC's commercial wisdom is final unless shown to be illegal or arbitrary. Unless it is COC ने अपने ही मर्जी से कोई भी उन्होंने डिसीजन लिया है, that is called as arbitrary, which is not based on any commercial wisdom. ऐसे ही रैंडम उन्होंने तुक्का मार के उन्होंने डिसीजन लिया है, which is obviously not in this case. Second thing is unless it is illegal. COC को कुछ फ्रॉड करना था, कुछ करना था, ऐसा कोई भी रीजन नहीं है दोस्तों इस केस में. तो अगर वो केस होता तो एनसीएलटी का लिक्विडेशन ऑर्डर रिजेक्ट करना मेक सेंस, अदरवाइज इट डजंट मेक सेंस. ओके. Number 2 is limited role of NCLT. The NCLT's role is limited to ensuring compliance with IBC provisions. NCLT को बस ये चेक करना है कि भाई IBC का प्रोविजन कंप्लाई किया है या नहीं. In SR Steel, if you remember the case now, write it. If you don't remember, don't write it. It's absolutely okay. In SR Steel, but I will make sure people in my course, I will give you every single real life case example for every provision I will be explaining you. Okay, इससे क्या होता है, you will be able to connect the dots very easily. Okay, in SR Steel and K Shashidhar, the Supreme Court clarified that tribunals cannot substitute their judgment for the COC's decisions. Number 3, judicial overreach. By overruling the COC, the NCLT exceeded its authority and violated the principle of creditor-driven resolution. Okay. Number 4, procedural compliance. The COC followed all procedural requirements under Section 33, subsection 2, and CRVI regulations. No illegality or procedural lapses justify the NCLT's interference. Okay. जब COC ने सारे procedural compliance follow किया है, then NCLT should abide by the commercial wisdom of the COC and it should not go against the COC unless 2 things. Number 1 is violating any law or the decision is arbitrary. अपने ही मन मर्जी से उन्होंने without any logic or practical sense उन्होंने COC ने decision लिया है. जब ऐसा situation नहीं होगा, then NCLT should not intervene. Okay. Now, judicial precedents, if you remember, quote it. If you don't remember, don't quote it. SR Steel Limited versus SR Steel India Limited Committee of Creditors versus Satish Kumar Gupta 2019 का केस है दोस्तों. Upheld the primacy of the COC's commercial wisdom, emphasizing limited judicial intervention by tribunals. Number 2, K Shashidhar versus Indian Overseas Bank 2019. The Supreme Court ruled that the COC's decision is final and binding unless it breaches IBC provisions or is arbitrary. Okay. Now the conclusion is the appeal by Gopal Limited has strong legal merit. The NCLT overstepped its jurisdiction by substituting its decision for that of the COC, contravening established principles of law. NCLT ये मामले में गलत था. The NCLT is likely to reverse the NCLT's order based on the following grounds. Number 1 is, देखो दोस्तों, आपका conclusion is NCLT गलत था. NCLT can pass an order in favor of the COC against NCLT. ये आपका conclusion है. अब ये कंक्लूजन आप क्यों बोल रहे हो ये भी आप एक्सप्लेन करना चाहिए दोस्तों, सो दैट सब कुछ इन सिंक में रहेगा आपका आंसर. logically, practically, it would all make sense. Okay, अगर आप randomly अगर आप conclusion देते हो, it would sound little dry. Okay, first impression and the last impression should be amazing in the minds of the examiner. Okay, the following grounds are: the COC's decision was in compliance with 33 subsection 2 of IBC. Number 2, the NCLT violated the Supreme Court's rulings in SR Steel and K. Sashidhar, which uphold the primacy of COC's commercial wisdom. COC उस चीज में गलत था, सही था, ये सुप्रीम कोर्ट ने अपहोल्ड किया था. Third is the NCLT's interference undermines the objectives of the IBC, okay, which seeks to provide a time-bound and creditor-driven insolvency resolution framework. Creditor are the kings, okay? Creditors के बाद ही सब लोग आते हैं people. तो creditors के against कोई NCLT ने order pass किया, then it is against the principle of IBC. Unnecessary delay होगा. देखो यहाँ पे NCLT ने just because गलत जजमेंट दिया है, इसके अगेंस्ट एनसीएलटी में अपील गया. इससे क्या होता है दोस्तों? टाइम गेट्स इंक्रीज्ड, व्हिच इज नॉट द सोल ऑब्जेक्टिव ऑफ आईबीसी. ओके, let's go to the next question, people. Creditor means any person to whom a debt is owed and includes a financial creditor, an operational creditor, a secured creditor, an unsecured creditor, and a decree holder. Define creditor and citing relevant case laws. Give your opinion regarding legal tenability of filing CIRP by decree holder. अगर decree holder ने CIRP initiate किया है, is it valid or not? ये हमें जवाब देना है along with the provisions involved and analysis and yeah. Okay. Let's see what should be the answer. Number one is you should always start with the title, people. Title is very, very important. Title is definition of creditor under IBC. मुद्दा ही ये है ना कि डिग्री होल्डर सीआरपी इनिशिएट कर सकता है नहीं. अभी सीआरपी कौन इनिशिएट कर सकता है? ये क्रेडिटर के डेफिनेशन में दिया होता है. ओके, a creditor as defined under section 3 subsection 10 of IBC code 2016 includes a financial creditor, an operational creditor, a secured creditor, an unsecured creditor, and a decree holder. Okay, this broad definition ensures that all categories of individuals or entities who are creditors can seek recourse under IBC. Okay, ये सारे लोग IBC का हेल्प ले सकते हैं whenever they initiate CIRP. Okay, now creditor में डिग्री होल्डर आता है, ये कंफर्म हो गया है. Now the question is, can a degree holder file CIRP is the question. ये भी हम एक्सप्लेन करेंगे in detail, people. A decree holder is included within the definition of a creditor having a court order. Court order उसके पास होना चाहिए that confirms a debt. Court order should confirm that the decree holder has a debt and can initiate a CIRP under section 7 as a financial creditor or section 9 as operational creditor of the IBC, provided the debt qualifies as a financial or operational debt and is unpaid despite of a degree. Okay, number one is, people, it should be a debt. Number two is it should be unpaid. Number three is he should have a court order. Court order what? Court order confirming a debt. These four things should be there. Okay, now if you remember case laws quoted, if you don't remember, it's absolutely fine. Okay, case law examples: Dena Bank versus C. Shivakumar Reddy 2021. The Supreme Court of India held that a decree holder is entitled to initiate CIRP under section 7 or 9 of the IBC. A decree evidences debt but does not alter the nature of the debt, and hence the decree holder can be classified as a financial or operational creditor depending on the underlying debt. Okay, वो operational creditor हो सकता है या फिर financial creditor हो सकता है depending on the debt. Okay, decree holder means, people, X has got the right to recover 2 crores from ABC Limited, which is under CIRP. Okay, भले ही X ने उसको पैसा दिया है या नहीं. For example, if Y has transferred the debt of 2 crores to X, okay, and Y ने ABC Limited को उसने 2 crores दिया है, Y does not want to recover from ABC. Y को X को देना है पैसे. तो अंडर कोर्ट केस क्या होता है? कोर्ट केस में जजमेंट आता है कि Y is supposed to pay X 2 crores. ओके, जब Y वहां कोर्ट में बोलता है कि मुझे ABC लिमिटेड को मुझे देने हैं 2 crores, then what the court will say is instead of ABC paying to Y, ABC will pay to X. Okay, hence X के पास डिक्री है. X is a decree holder where he can claim 2 crores, claim or recover, I would say, people, 2 crores from ABC Limited. ठीक है, this means decree holder. अब it depends on the debt, whether it is financial or operational debt. Okay. Second case says Praveen Jain versus Nice Projects Limited 2018. In this case, NCLAT clarified that a decree holder qualifies as an operational creditor if the underlying debt arises from goods or services. Okay. Only this case, I think people you should quote. This I don't think you should quote, but in case if you remember, आप डाल सकते हो. For a decree holder to file for CRP, the decree must confirm a debt owed to the decree holder. The debt must meet the threshold limit under IBC, currently 1 crore. The decree holder must establish that the default persists despite the court decree. जब कोर्ट ने ABC को बोला है कि X को 2 करोड़ देना चाहिए तुमको और X अभी तक ABC ने नहीं दिया है, then decree qualify होता है people. Decree होता है, debt होता है, and then 2 crores, that is 1 crore से ऊपर वाला threshold भी match होता है. Okay. The conclusion is a decree holder has the legal tenability to file a CIRP under IBC provided the underlying debt qualifies as financial or operational and remains unpaid. Okay, तो यहाँ पे दोस्तों हमने शुरू किया था by definition of creditor under IBC, then can a decree holder file CIRP, ये हमने इंक्लूड किया था along with case laws, and then decree holder to file CRP क्या क्या चीजें होनी चाहिए, and then conclusion. Okay, इस तरह से जब आप आंसर लिखते हो people, it is so much detailed and well structured answer. All are connecting the dots. सारे paragraphs are in flow with each other. No, this creates an amazing impression in the minds of the examiner. He will obviously give you at least 4 out of 5 marks for this. Okay, this is what makes a difference people apart from 99% of the question papers that he will be checking. Okay, 99% of क्वेश्चन पेपर में क्या होता है दोस्तों, वो लोग प्रोविजन समझाएंगे, अपना इशू इन्वॉल्व बोलेंगे, एनालिसिस बोलेंगे, कंक्लूजन बोलेंगे, दैट्स इट, दे आर डन. बट यहाँ पे आप क्या कर रहे हो, हाउ थिंग्स आर इंटररिलेटेड टू ईच अदर, ये आप एक्सप्लेन कर रहे हो. यू आर नॉट राइटिंग द आंसर, यू आर लिटरली एक्सप्लेनिंग द आंसर टू द एग्जामिनर. ओके, it is cake walk for him to read the answer, go through it, understand it. Once he understands it, obviously matlab he can easily give you marks. ठीक है, this is how you should create an impression people. This is all about making sales. No, आप एग्जामिनर को कन्विंस कर रहे हो कि भाई you should give me 4 out of 5 marks or I deserve 5 marks. ठीक है, this is what this X, Y, Z points is what sets me apart from 99% of the question paper. ठीक है. The next question is, X was appointed as an official liquidator of ABC Company Limited. At the time of passing of the order of winding up by NCLT, after a few months, X suffered a cardiac arrest. And due to a sudden demise, X died. His position has become vacant. Elucidate the powers of tribunal with respect to removal and replacement of liquidator in place of X under section 276 of the Companies Act 2013. Okay. Now let's see what are the powers of the tribunal under section 276 of the Companies Act 2013. 2 minutes paper. Okay, let's start. Section 276 of the Companies Act 2013 empowers the tribunal to remove and replace the official liquidator when a vacancy arises. This includes situations such as resignation, incapacity, or demise of the liquidator as seen in the given case. Either liquidator had died or liquidator is not able to perform his function due to incapabilities or he resigned. In cases में कैसे liquidator को replace करना चाहिए, what all provisions are included, we need to explain them over here. Okay. Number one, you should always start with legal provisions. So what the provision says, the tribunal may remove the liquidator if it is satisfied that the liquidator has misconducted, failed to perform duties, or is incapacitated. The tribunal can act suo motu on or on an application made by creditors, contributors, or any aggrieved party. Okay. Filling the vacancy. When a liquidator's position becomes vacant, the tribunal has the power to appoint a replacement. This ensures that the winding up process continues without disruption, safeguarding the interest of creditors and stakeholders. चाहे कुछ भी हो जाए, creditors and stakeholders का interest should not be compromised. In liquidator चाहे liquidator का demise हो जाए या फिर he becomes incapacitated or he is not able to perform his duties or he resigns, चाहे कुछ भी हो जाए, he should be replaced immediately so that creditors and stakeholders का interest should not be compromised. Number 3, qualifications for replacement. The new liquidator must meet the eligibility criteria under section 275. Section 275 talks about the eligibility criteria of the liquidator. The replacement may be a professional registered with the Insolvency Bankruptcy Board of India or someone deemed fit by the tribunal. Obligations of the new liquidator. The incoming liquidator must take charge of all records, assets, proceedings. They are responsible for continuing the liquidation process from where it was left, ensuring compliance with section 290 regarding reporting and record maintenance. Okay. यहाँ पे दोस्तों आप पहला चीज समझा रहे हो कि लिक्विडेटर को रिमूव कब किस केसेस में हो सकता है, वैकेंसी कैसे फिल करना चाहिए, वैकेंसी फिल करने के लिए क्या क्या क्वालिफिकेशन रिप्लेसमेंट होना चाहिए ऑफ द न्यू लिक्विडेटर, एंड वंस द लिक्विडेटर इज रिप्लेस्ड what are the duties and obligations he should perform after he is replaced. You know, you are explaining this answer stage wise. In this case of demise of X, the official liquidator of ABC Company Limited, the tribunal will verify the cause of vacancy, the tribunal should confirm X demise and check the official records. Number 2 is initiate appointment process, issue directions for appointing a replacement, ensuring qualifications and experience as per legal requirements. If the liquidator who died had 10 to 15 years of experience, obviously the next liquidator should be appointed in the same way who has got the same relevant expertise and experience. Number 3 is transfer responsibilities. Oversee the transition of duties to the new liquidator, ensuring no lapse in the liquidation process. Liquidation process में कोई भी error या lapse नहीं होना चाहिए because of this transition. The conclusion is the tribunal must swiftly act to appoint a new liquidator for ABC Limited after X demise, ensuring uninterrupted winding up proceedings. Tribunal should ensure that the transition की वजह से it should not, winding up proceedings should not be interrupted. Okay. This is how you should write the answer, people. Let's move to question number 11. Sarvam Technologies Private Limited is not carrying on any business or operation for a period immediately preceding 2 financial years and has not made any application within such period for obtaining the status of dormant company under section 455 of Companies Act 2013. Number 1, 2 years में business operations नहीं किए. Number 2, dormant status, he has not applied for dormant status with the tribunal. The board of directors of Sarvam Tech Private Limited intend to file an application for removal of name of the company from the ROC. The board of directors called a meeting of shareholders and 66% of shareholders in terms of paid-up share capital gave their consent to the proposal, and thereafter the application was filed with the ROC. We need to discuss the tenability of the application filed with ROC for removal of name. Okay. इसके बाद 66% of shareholders ने consent दिया for what? For winding up. Okay. They are trying to confuse the people. उन्होंने 2 condition बोले जो कि comply करना चाहिए for winding up, and then consent भी लिया बोल रहे for shareholders for winding up. But यहाँ पे दिक्कत ये आती है दोस्तों, दिक्कत is 66%. Is it 66% or what? We will see. Okay. Relevant provisions under section 248 subsection 2 of Companies Act 2013. A company can apply for striking off of its name if it has followed 2 conditions. Number 1 is it has not been carrying on any business or operation for 2 financial years immediately preceding the application. Number 2, has not made any application for the status of a dormant company under section 455 of the Act. ये रूल उन्होंने कंप्लाई किया है. Number 2 is key steps to apply for removal of name. You should also explain removal of name के लिए क्या-क्या steps follow करना होता है. Approval of the board of directors लगता है दोस्तों. The company must pass a special resolution or obtain the consent of at least 75%. यहाँ पे आपका आंसर आता है. 75% of shareholders in terms of paid up capital. An application should be filed with the ROC using form STK2. That is the form which is required to file documents, which is required to file the form. This is the form for striking off the name of the company. Now, what is the analysis? In the given scenario, non-compliance with shareholder consent requirement. Only 66% of shareholders consented to the proposal. However, the law mandates a minimum 75%. Number 2 is lack of dormant status application. जब dormant status उन्होंने file ही नहीं किया है, then they are eligible to file to strike off the company. The company did not apply for dormant status, which is not a disqualifying factor, which aligns with the legal requirements for striking off. The outcome is the application is untenable because the consent threshold of 75% was not met. This deficiency makes the application invalid as per the Companies Act 2013. है ना? यही चीज दोस्तों, this is very 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 important. Examiner had confused you. उन्होंने सारी चीजें राइट बोले, ये भी राइट बोले, ये भी राइट बोले, बट यहाँ पे उन्होंने गलत बोला, so that you will be confused. है ना? 66% जैसे आप देखते हो, you will immediately associate this with IBC का 66% of COC का voting approval. है ना? They are trying to confuse the people, but you are not supposed to get confused. यहाँ पे 75% लगता है और वहां पे 66%. Okay? Let's move to the last question. I think last question है ये, last question. Yes, this is the last question, people, of CRVI December 2024 attempt. Okay, let's see. Let's jump back to the question. Critically, critically dwell upon or describe relevant enabling provisions for cross-border transactions under insolvency bankruptcy code. Critically examine ये सब रहने दो. वो क्या बोल रहा है? क्रॉस बॉर्डर इंसॉल्वेंसी का प्रोविजंस कि क्या बेनिफिट्स है, क्या डिसएडवांटेजेस है, क्या फीचर्स है, आगे जाके क्या उसमें वी कैन मेक चेंजेस सो दैट आगे जाके the process becomes simpler, objectives will be achieved, है ना? Number one is advantages, features, disadvantages, loopholes क्या है, what changes can be made, we need to critically examine, that is called as critically examine. Okay, दोस्तों यहाँ पे मेरा आंसर देखो मैंने कैसे लिखा है. This is how the answer will be. You will find it in my notes. Very easy to understand, highly logical, practical, and knowledge addition बहुत होगा उसमें. Even if you don't remember the answer during the exams, मेरे notes पढ़ के you will be able to connect the dots very easily. You will be able to write the answers very logically and practically. है ना? The notes is not bookish like other modules. Okay, I will not talk about other modules, but my notes is not bookish, people. मैंने जो भी notes बनाए हैं, it is highly logical, practical based approach. You will be मतलब मक्खन जैसे आप आंसर लिख सकते हो मेरे नोट से पढ़ोगे तो. Okay, so let's jump back to the answer. Always start with the provision. Okay, the Insolvency Bankruptcy Code 2016 addresses cross-border insolvency through Section 234 and Section 235. Okay, though these provisions are limited in scope and largely land on reciprocal arrangement with other countries, just because India follow कर रहा है cross-border insolvency provision, that does not mean अगर यूके में एक बंदा बैठा है we can recover dues from him. No, that's not possible. Only if UK and India collaborate with each other and decide कि we are going to follow cross-border insolvency provisions, एक framework हम follow करेंगे, then it makes sense. Otherwise, it doesn't make sense, people. That is called as reciprocal arrangement. UK, India, US, XYZ countries. Okay. So let's see what are reciprocal arrangements. Section 234 allows the central government to enter into agreements with foreign countries for enforcing the provisions of the IBC in cases of cross-border insolvency. Okay. First thing we need to write, Section 234 में क्या cover होता है? What it talks about? It talks about entering into agreements with foreign countries for enforcing the provisions of IBC in cases of cross-border insolvency. Okay, now what are the key features of Section 234? The agreement enables cooperation between Indian and foreign courts or authorities. Okay, cooperation between foreign courts and Indian courts authorities. It ensures that insolvency proceedings in India can be recognized and enforced in a foreign jurisdiction and vice versa. India, UK. विजय माल्या. अगर इंडिया एंड यूके आर not in agreement, then they cannot recover dues from विजय माल्या. है ना, ये चीज वो बोल रहा है. Imagine an Indian company has significant assets in the UK and the company undergoes insolvency in India without a reciprocal arrangement under Section 234. Indian authorities cannot enforce their decisions in the UK unless UK laws independently allow for such recognition. समझ गए बात? यही चीज मैं बोल रहा हूं आपको. Number 2, section 235, letter of request. What it covers? Section 235 allows an adjudicating authority to issue a letter of request to a foreign court or authority to handle assets or proceedings related to the corporate data located in a foreign jurisdiction. इंडिया में एक कंपनी है, यूके में एक्स डैश कंपनी है which is a subsidiary of X Limited. The NCLT may direct the appointed insolvency professional to approach the foreign court through a formal request. This is particularly useful for managing assets abroad or ensuring creditors in other countries are part of the insolvency process. If an Indian company undergoing insolvency has a subsidiary in Singapore, the NCLT can issue a letter under Section 235 requesting the Singapore court to take necessary action. However, Singapore must have reciprocal laws or agreements with India for the request to be honored. यहाँ पे इंडिया लेटर ऑफ रिक्वेस्ट देता है कि भाई प्लीज हैंडल द एसेट्स in XYZ format so that dues will be recovered properly by the stakeholders or creditors. Of not only India but also UK. Okay. Now we have quoted section 234 and 235, letter of request and reciprocal arrangements. Now we need to tell them exactly problem kya ho raha hai at present. When an Indian company goes bankrupt, there is often a problem. The company has money, property or debts in another country. Why? The reason is because India doesn't have strong rules to deal with international insolvency cases. Now, why doesn't this work well? No agreements with other countries. India has not signed enough deals with other countries to help with such cases. Number 2, too simple for complex problems. Big companies like Jet Airways often have properties, debts, or creditors in several countries. The current rules don't handle such complicated cases. India did not adopt a global rule. There is a worldwide system called UNCITRAL model law, which many countries like the USA and UK use. It makes solving cross-border bankruptcy cases easier, but India has not adopted it yet. Now, what's a UNCITRAL model law? It is a universal playbook for handling bankruptcies across countries. It helps by 3 things. Recognizing foreign cases. If a company goes bankrupt in India, foreign countries will accept it and cooperate. Number 2, direct access. Indian bankruptcy experts can directly work with foreign courts. Smooth coordination. It ensures courts in different countries work together, avoiding the confusion. 3 चीजें होती है दोस्तों. Recognizing foreign cases, which at present it is difficult. Number 2, direct access. Directly we can access foreign courts. Number 3, smooth coordination between different countries and different courts. Okay. अगर UNCITRAL model हम adopt करते हैं, then these are the advantages. Okay. Now, why does it matter? If you explain this using a Jet Airways example, na people, amazing, truly amazing. I always tell you people, always the first impression and the last impression should be very much amazing in the minds of the examiner. Now, if we explain this using this, take the Jet Airways example. Jet Airways had assets like airplanes and offices and creditors. People it owed money to in multiple countries. Multiple countries में इनके creditors थे. Indian laws didn't have a clear system to handle this, leading to delays and confusion. If India had the UNCITRAL model law, the process would have been much, much smoother. People, I love this part of the answer. Amazing answer. ठीक है, जब ऐसे आंसर लिखोगे ना दोस्तों, you imagine 99% of the answer sheet, I will say 99.99% of the answer sheet में ऐसे आंसर होंगे ही नहीं, बिल्कुल भी नहीं होंगे. It will be properly bookish language, you know, normal answer होगा उनका, provision, analysis, conclusion, that's it. But you, in this scenario, you are going 10 steps further. आप explain कर रहे हो along with examples. You are literally teaching the examiner the provisions and laws. That's amazing, huh? You should write the answer to teach and inform, not just to answer. Okay? So here comes the end of the question paper of CRVI December 2024. Attend people. That's all from my side. If you like this video, please like, share, and comment. Thank you so much for watching. I will see you in the next one.